Hey everyone, Attorney Jesse Arana here, and today we're going to be talking about what is a DMV administrative per se hearing after being arrested for an alleged DUI. Now please understand that there are APS hearings for other incidents such as being involved in an accident or being accused for a hit and run and not having proof of insurance. But today we're going to be talking about what is an APS hearing, administrative per se hearing, after being arrested for an alleged DUI. An APS hearing is not criminal. In other words, DMV will not impose any points on your driver's license, will not put you on any type of criminal probation, and will not impose any type of criminal conviction. DMV, after this APS hearing, will decide to do either impose a license suspension or revocation, and for how long, or they will do what's called set aside. A set-aside means they are going to take no action and not suspend your driver's license at all. An APS hearing is led by someone known as a hearing officer, as well as the respondent, that's the person who is accused of an alleged DUI, and his or her legal representative, such as myself, the defense counsel. The hearing officer, really fancy title, I know, right, is literally a DMV employee. It is not an attorney. It is not someone who went to law school. It is not a judicial officer. A hearing officer is only a DMV employee who received some training, went to a seminar, and received permission to conduct these APS hearings through the title of hearing officer. I know. This hearing officer is going to have three roles. They are going to behave like a judicial officer, and they are going to decide what evidence is admissible and what evidence is inadmissible. So for example, if I, like the defense counsel, say objection, that evidence is inadmissible for lack of foundation, or as hearsay, inadmissible hearsay evidence, the hearing officer will decide, overruled, I'm going to let that evidence in, or granted, sustained. You're right, counsel, that evidence is not admissible. They will individually decide what evidence is admissible and what evidence is not. This hearing officer is also going to behave kind of like a prosecutor. In other words, they're going to try to prove that you were actually driving under the influence of alcohol or drugs or a combination thereof. To make things worse, they're also going to behave like a juror. In other words, they are going to decide individually whether you were actually driving under the influence of alcohol or drugs or a combination thereof. I don't see how this makes any sense, how one person can be the judge, the alleged prosecutor, and the juror, and at the same time be expected to be fair. It doesn't make any sense to me. Even though this hearing, I think, is not fair, I believe it's really important for three reasons. Reason number one, your license, assuming it was valid prior to the alleged DUI, will continue to remain valid until this hearing is conducted and a decision is made. You will be granted what's called a stay on your license suspension pending the outcome of the hearing. In other words, you will be allowed to drive. Again, this is assuming you had a valid driver's license prior to the DUI arrest. You will be allowed to drive without any restrictions, without the requirement of having to install an ignition interlock in your vehicle, without restrictions on where you can go, such as work and only the DUI program. No. With this temporary driver's license, assuming you didn't have any restrictions beforehand, like having to wear eyeglasses, you will be allowed to drive anywhere you want without any restrictions during any time of the day, pending the outcome of this hearing. The second reason why I believe this hearing is so important is because this is one of the only ways, if not the only way, to save your driver's license. If you do not request an APS hearing, you are giving up your right to challenge DMV. And DMV, I would say 9 out of 10 times, will rule against you and suspend your driver's license. So by demanding a hearing, you're saying, no, DMV, you have to prove it that I was an alleged DUI to suspend my driver's license. And a defense counsel like myself can then challenge DMV and argue for a set-aside because the client was not driving under the influence of alcohol or a combination thereof. And the third reason why I believe this hearing is so important, the reason I like to do these DMV hearings, is because of the power of subpoena. The power of subpoena means I, the defense counsel, can subpoena, order, command the arresting agency to give me any and all alleged evidence surrounding my client's DUI arrest. So for example, if it's CHP, CHP has patrol car audio video recordings called MVARs. If it's LAPD, they have body cameras. Regardless of the arresting agency, I get to subpoena them and order them to give me any and all evidence, including audio, video, recordings, breath machine records, traffic collision reports, arrest reports, etc. I can even subpoena the arresting officer to testify in the DMV hearing. If your blood was drawn, I can also subpoena the person who withdrew the blood and challenge their credentials as to whether they withdrew my client's blood in a medically approved manner. So that is the third reason why I believe this DMV hearing is so important. And the way I utilize this power of subpoena is the following. When a client is arrested for an alleged DUI, they are given a citation. It kind of looks like a ticket. And in that citation, it says you have to appear in court months, usually months from the date of the arrest. So from the moment I actually request and get a hearing date on this administrative per se hearing, then I subpoena the arresting agency for any and all relevant evidence surrounding the arrest. And the goal is to get all of this evidence prior to the criminal court hearing. So what I do is, assuming I get this evidence, I then review all of the pertinent alleged evidence surrounding my client's DUI arrest, and I can study it and see what are the relevant defenses for my client. So this way, when I step foot in my client's first criminal court hearing, I already know what are the legal defenses for my client. And that really does help me in getting awesome results for my client. Now, like I said, this hearing is really important, even though it's not fair. And so it's really important to demand this hearing within 10 days of the date of your arrest. If you don't do that, you are giving up your right. You can still request a hearing 10 days after your DUI arrest, but you have to explain why they should give you this exception. And usually DMV says, no, we're not going to grant you this exception, and your request for a hearing is denied, and your license is then suspended within 30 days from the date of your arrest. You have to understand also that these 10 days includes weekends and holidays. So if you are arrested, for example, on a Friday, Saturday, and Sunday, do count in calculating the 10 days. If you yourself have been arrested for an alleged DUI, need legal representation, or have any questions about this DMV APS hearing, please don't hesitate to call me. My office phone number is 562-392-8209. Again, that's 562-392-8209. You can also find more information about me and my contact information on my website at www.jessearanalaw.com. Again, that's www.jessearanalaw.com. All right, guys, be safe.